first of two sexual assault trials against Magna Auto Parts founder Frank Stronach is underway in Toronto. The billionaire Canadian businessman is facing a dozen charges involving 7 complainants. The allegations relate to alleged incidents that happened from the 1970s to the 1990s. Originally, Peel Regional Police charged Stronach with 18 offences, but the case was later split into 2. The second trial is set to take place in Newmarket later this year. Stronach has denied all of the allegations against him. The judge-alone trial is expected to last 4 weeks. Joining me now is Nick Cake. He's a criminal defense lawyer. Nick, good morning. Great to have you with us. So let's begin with why this case was split into 2. Is that unusual?
No, it's not unusual. It likely has to deal with jurisdictional issues. Obviously, the Magna Empire was created in the Newmarket, Aurora area, which makes sense as to why he would face trial in Newmarket. These offenses likely alleged to have happened in Toronto, which is why they're taking place in Toronto.
So how will this first trial work then?
Well, it'll work like any other trial. The Crown has the burden to prove guilt beyond a reasonable doubt. Mr. Stronach does not have the burden to prove his innocence. The Crown is going to call evidence. I think the problems here are going to be with the frailties of human memory. We're talking about some offenses that took place some 50 years ago. So the Crown's going to have to deal with witnesses who may not remember, with the inability to secure physical evidence and things like that. I mean, there may even be witnesses to some of these alleged offenses that are no longer with us. You know, Mr. Stronach's not going to have an easy time either. If he wishes to testify, which he doesn't have to do, he has the right to remain silent. But if he testifies, you know, it's a lot easier to say, I was here or I was there if the allegation was a week ago or a month ago or even a year ago. You know, check the calendar, check your text messages, your emails, and so forth and so on. But it's really hard to place yourself some 40, 45, 50 years ago as to where you were at a specific time. It's going to be a difficult case for both sides.
It's a judge-alone trial. Does that usually play in the defense or the prosecution's favor?
I don't think it plays in anyone's favor because ultimately the law is the law and the judge is there to make that decision. The judge is, of course, going to know the rules of evidence and is going to be able to separate themselves from anything that is inadmissible, perhaps easier than a jury would do. It should be a more streamlined trial because there's not going to be a lot of stopping to explain to the jury, you know, this is what's happening here, or excusing the jury to talk about evidentiary issues. So that's one of the benefits, is that this trial should run, it should start, it should finish, and it should run smoothly.
And then we said that the trial will take about a month. Will the judge make a decision shortly thereafter? How long will Mr. Stronach have to wait? Will he know the verdict before the next trial starts?
Well, I guess that depends how overworked the judge is, really. If there's a month of evidence, then certainly you would want the judge to retire into their chambers and take some time, a week, maybe 2, to give their verdict. If this trial runs super smoothly and maybe the evidence is all done in 2 weeks, and then there's that 2-week period of time where the judge can write their decision because they would have been scheduled in that courtroom anyway. But I do think that once the evidence is completed, the sitting justice will want to take their time and make sure that they ground their decision in the evidence that they heard.
Nick Cake, thanks so much. We'll talk to you again, Nick.
I'm here.